continue on with our Court of Appeals candidates. I don't know if you are aware, in the state of Ohio, the Court of Appeals is divided up into 12 different districts. Darke County happens to be in the 2nd District Court of Appeals, which consists of Champaign County, Clark County, Darke County, Greene County, Miami County, and Montgomery County. So if you haven't seen these gentlemen here in Darke County campaigning a whole lot, there could be a reason why. They've got a big area to cover, so they can't be in Darke County for every event. But with that, I'll go ahead and introduce Chris Epley and Jeff Rezebeck, and we will go ahead and start with our 3-minute introduction from Mr. Epley.
Thank you, Cindy. I'm a husband, a dad, and a lawyer. My name is Chris Epley, and I'm a candidate for the 2nd District Court of Appeals. I was born and raised in the Miami Valley. I'm from Dayton. My wife, Eileen Epley, and I have been married almost 18 years. We have 2 children. My son, Jack Epley, is 16, and my daughter, Lily Epley, is 14 years old. My parents raised me to be active in the community. I served a term on the local school board, and I'm currently serving my 2nd term on city council. My parents raised me that way, and I'm really happy to introduce you to someone I've known over 51 years who joined me this morning. Sitting here in the front row is my mom, Connie Epley. So I'd like to thank her for leaving our neighborhood at 6:30 this morning to be here today. Regarding my legal experience, which qualifies me as your Court of Appeals judge, I've been a lawyer for over 20 years. In addition to being an attorney, I'm an assistant prosecuting attorney, I'm a part-time magistrate, and I'm also an adjunct professor at the University of Dayton School of Law. Regarding my prosecuting attorney experience, I work in the Vandalia Municipal Court. That court is an active court. It includes many jurisdictions: Vandalia, Union, Clayton, Inglewood, Harrison Township, Butler Township, and the Ohio State Highway Patrol. There I do trials and appeals. I serve as the Chief Appellate Counsel in that court. In addition, I've been appointed as a Dayton Municipal Court Magistrate. That's a part-time position, almost an as-needed position. So what I do there is I hear trials, both criminal and civil. Now, as a magistrate, you're appointed. You can also be appointed as a judge, but eventually as a judge, you have to be elected. So I've kept my appointment as a magistrate for the past 10 years. In addition, I've taught appellate practice and procedure at the University of Dayton School of Law for the past 17 years. In that class, I prepare a simulation for the students, both for and against an argument. They research and draft a paper, and they draft some more until the final paper is due, and then they argue it orally in front of myself and 2 other lawyers that I bring in as judges for us. So the 2nd District Court of Appeals is a very important court. I believe in a conservative and a measured approach to decision making. I respect our legislator. All that they do, they create the laws, judges interpret the laws. That's how I see as my role, and I appreciate your vote on March 17th. Thank you very much.
Thanks, Chris. My name is Jeff Rezebeck, and I'm running for the 2nd District Court of Appeals, and I would ask for your vote. And I'd give you a couple things about why I think it's important, why I have a unique ability to serve on that court. I grew up in Western New York, in Buffalo. I came to the Dayton area to go to the University of Dayton. I went to the undergrad, as well as graduated from law school there. I then made a hop back to New York for a quick second, passed the New York bar, but the day I found out that I got to pass the New York bar, I got a job in Dayton, Ohio. So I had to come and take this bar here as well, and pass that. And I've been practicing for almost 24 years now. I had a unique opportunity and unique experiences. I've also served as the substitute Dayton magistrate, as Chris is doing. That gives us background and starting experience. I've also had the opportunity to serve as a state legislator for the 43rd District, which is just south of here in western Montgomery County and all of Preble County. Had the great honor of serving with Representative Beakey, who I consider to be a mentor. That gentleman has such a background. He was the one that introduced me around Preble County, because as you all know, he knows everybody. And he just gave me the experience of what a great legislator should do and how they should do it. And that experience of being a legislator, of how laws are made, and actually being in there, it's quite different than you think. And having that experience now, going forward to sit as a 2nd District Court of Appeals judge is very valuable. The other valuable position that I've held is judge of the Montgomery County Juvenile Court. Held that for a period of time, and it is a unique experience to sit there and make decisions. These are individuals and families that come before you, and to have that in the game experience, I think is vital to understand when you, as a Court of Appeals, basically are reviewing what those trial court judges have done and what has happened in those trial courts. I also have over 70 felony jury trial experience, criminal jury trials. I have also had experience in every county that we would be representing. I do ask for, with all of that experience and all that unique experience, I think that makes me uniquely qualified for this position, and I would ask for your vote on March 17th for the 2nd District Court of Appeals.
Thank you, gentlemen. And with the first question I had, I think that, Jeff, you kind of answered some of that, but how much trial experience do you have in trying cases?
Sure. Most of the people that know me in all the counties that I practice in know me as basically a litigator, a trial attorney. I'll give you one story to tell you about my trial experience. I joined a firm with 2 attorneys, Mr. Smiley and Jay Carter, and most of the time you start at like a lower level court, municipal court, and move on up to felony court and all that. Mr. Smiley said, no, we're gonna throw you right in. And we did. I substituted in for Mr. Smiley in the case, and as unique as it is, won my first jury trial, first trial ever, okay? And we did that, and again, it's that experience, that mentorship that I received along the way from those individuals. So my trial experience is very extensive on the criminal side as well as on the juvenile side. Most people also know me, and I think they'll know Chris as well, as guardian ad litem and attorneys for the parents, especially in Montgomery County. Of course, I go to multiple counties representing parents and children. But those are, we may not call those, we call them as hearings, but there are extensive trials that we're defending either a parent's right to continue to parent or a child's right on where they want to live, or even on the delinquency side. I have an extensive amount of time in the courtroom and being active at all levels, whether that's at the municipal level, felony level, or even federal court.
I've had cases in all 6 counties that make up the 2nd District Court of Appeals. I try cases weekly. In the Vandalia Municipal Court, I'm there Mondays and Thursday mornings, so we have cases every week that go to trial. It's an interesting story. I started in Vandalia Municipal Court in January 2000. I was a pretty new lawyer, and I was getting used to trying cases because some of them can be tried simply on an Ohio State Patrolman's witness. What is your name? And they go through the whole case for you. That's not really the way it's supposed to be done, but some would do that. So I was getting confident a couple months into my job, and so I didn't bring up my notes. I'm a really prepared person. I bring my notes to everything. But then I was getting a little bit overconfident. This was in 2000, because I was a newer lawyer thinking this is how it's done, and the judge said to me, I don't want to ever see you do that again. Always bring your notes with you. Now, I didn't lose the case. It was an easy case, frankly, because I had a great witness, not because of me. The witness made the difference. But I practiced law in family courts, juvenile law, probate court, civil court, and criminal court. So I've been in most of those jurisdictions that come to the Court of Appeals. In addition, I have the experience as a counsel person where we hear administrative hearings. Those type of things also get appealed to the trial court first and then to the Court of Appeals. And so I think those experiences qualify me as your next judge.
how much experience have you had briefing in front of the Court of Appeals and the Supreme Court, and what has your success rate been?
On the prosecution side, undefeated. On the defense side, not so much. So sometimes those are tough cases. They may go to a jury trial or a bench trial. And so you have an automatic right to appeal to the Court of Appeals. So when someone is sitting in prison, it's pretty easy to say, I would like to have an appeal, and they probably should, because they're entitled to it. So as long as the trial court and the judge did everything right, that appeal is hard to overturn. A Court of Appeals judge's role is to judge the judges, so they're going to make sure that the rules of evidence have been followed in the Court of Appeals. On the other hand, when I'm prosecuting those cases, whether I've tried it or the other prosecutor has tried it, when we go to the Court of Appeals, generally we certainly go second, and we have a much easier case. So I go to the Court of Appeals quite frequently. In fact, just last week, I was called for a second opinion out of a Warren County case. A client called me and said, my attorney who did my trial wants a second opinion. He's telling me that I should appeal it, but he referred me to you. So I'd like to send you the decision, all the briefs that were done, the memos, and so forth. And what do you think? So I reviewed it and I said, well, I think there's an issue here. There's some split in authority. I think you have a shot, and referred that back to him. Now, he said to me, well, can you do it? And I said, well, really, you should go back to your attorney. I don't want to take that case from him. This was merely a second opinion. And that happens in our profession, and I'm happy to do it. So I told him, I think you have an issue. Go back to your trial attorney and see what he says. I think you have a shot there.
The number of appeals that I do is not as much as I do as the trial court. But one of the things that we do at the trial court as an attorney is to make sure the record's clear and to make sure that there's not issues for appeal. You raise those issues. If you happen to lose, then you do raise those issues. I probably do more appeals or filing of appeals on, in juvenile cases where parents have lost their permanent custody. And we're really trying to get an understanding to that Second District Court of Appeals. There's never been a juvenile court judge to sit on the Second District Court of Appeals. And there's only been a few legislators that have sat up there. That's why I think it would be a unique opportunity to actually have someone who has experience on the bench, making those calls, then reviewing. It's like almost being like an armed, that Monday morning quarterback, right? Unless you've been actually in the game and you sat as a common pleas judge and you're making those calls, I think it's important to be a part of that. And Chris is right. It's much easier on the prosecution side, especially on appeal if you've done it. Or actually, I should say, if you've won at the lower level, typically it is much easier. It's where you're challenging, those, whether it's an ID on a criminal case or even on a civil case, what that law actually is, and trying to locate those slight differences that can make a difference that maybe the lower level missed. And that's what you would try and do on an appeal. I think we've done a very good job, but it is, when you go to that Second District, you're following prior precedent. You don't get to make a lot of your own things, and you shouldn't. You should look at that prior precedent and look at the way the statute was written and apply it to the facts that are there. Additionally, you should also make sure that you're reading all of those transcripts and you're looking at the participation of that judge.
Okay, who is your favorite Supreme Court candidate, or excuse me, Supreme Court justice, and why?
Well, I probably have, and this is how I look at things, that I'm more of a textualist, but I think that just because of my upbringing, so that would put me in the Scalia camp and even in the Thomas camp. I think the way, and when you read Scalia's, some of his famous dissents, you have to really look at, and I almost consider myself pragmatic, you gotta be careful with that word, but a practical textualist, Because you got the words matter. At the legislative level or at the constitutional level, those words were chosen. Okay? And the pragmatic part of that is that they have a certain meaning at that time. Okay? And then you have to apply that to what it means now. Okay? You can't make it up. You can't guess at it either. And those are what we have. Especially in the state legislature, as I learned, one of those things, you choose your words wisely when you're trying to make a law. There have been so many times, and it was very frustrating, especially at the end of a legislative session. It's called the lame duck. And one of the most difficult things for me to really work with other legislators on, especially the leadership, was come mid-December, we are throwing everything in there you can and not reading it and not understanding it. And then what you do is you leave it to the next group to fix whatever was wrong originally. And I'll give you one quick example. We were, at 3 in the morning, they put a provision in there to put metal detectors in every government building in Ohio. Do you know how much that would have been? Over $1 billion. Because you know how many government buildings there are in the state of Ohio? Every little building. So we had to catch that language, and we did. We caught it and saved it, but it's that importance of what we're trying to do. Thank you.
So I can't say Chief Justice John Jay, because he's not current or living. I like the temperament of Clarence Thomas. To me, the way he rules from the bench, his temperament is impressive. I'm interested in seeing how Neil Gorsuch goes forward. He's one of the newer members of the Supreme Court. He's a year older than I am. So when I think of him, he's my generation. So what decisions are coming from him? We've seen what have been, but what are coming from him? When I teach my class, we certainly look at the Supreme Court justices and their decisions. Depends which side of the argument you're on in my simulations, because there's an obvious split. And you have to follow one side or the other. So we talk about them. We look at them. We look at, are we looking at the liberal side or the conservative side? Well, it depends which side you're on in my class. And people come up to me, that's a criticism. Well, I didn't want to be on this side. I'm conservative. Well, you'll have to learn the other side, because when you're practicing, you do have to follow the law. And so when we look at who our favorite Supreme Court justices currently, I do miss the words, the language, the textualism of Justice Scalia. And I think many of my students would read his decisions and be impressed by the language of them. They would be impressed by him going back and reading and studying the Constitution. And what did the framers mean by that language? And I think that's important. Language means language. That's what it is. We don't go back and interpret different words to mean different things. The language is there. And so I would say that my favorite justice is, I hope to be, the one who is my generation, who is my age.
Okay, do you prefer solving trial court errors or remanding them back, or do you prefer solving the errors of trial courts in your opinions or remanding it back to the trial court?
That happens both ways, right? Some situations you have to remand. So what does remand mean? Let's say there was testimony that the damage to a car was $5,000, and the trial judge then determines in a decision that the plaintiff only receives $3,000. Do you remand it to the trial court and say, rehear the whole case because the testimony in the transcript says $5,000 and you said $3,000? Or, as a Court of Appeals judge, where we're grading the judges, we're grading their papers, do we say, we read the transcript, we see that the witness stated, without cross-examination, the witness stated it was $5,000 in damages. So then we would remand it to say, trial court, put $5,000 as your decision. We don't remand it and say, retry the whole thing. So the Court of Appeals does correct the trial court decisions. That's what they do. And that's what they're supposed to. Whether it has to be remanded to correct it or remanded to have a whole new trial are two separate issues. Because if it was unfair, if 3 different witnesses said, well, it was between $3,000 and $8,000 and we're not really sure, and then it was arbitrary with the decision from the jury or the trial judge, well, then you probably have to remand that and have a whole new trial. But when we think of the time management, do we want to send every trial back for a new trial when it's clear from the transcript what the answer is, what the decision is? No, I don't think we do, because we just wouldn't be able to hear all the cases. And it's important to all the parties. They need their day in court. They need the right decision.
In remanding and looking at a trial case, I think it's important, like, one of the things that you do as a sitting judge in juvenile court, as well as common pleas, you said in cases, the cases come from the magistrate. So the magistrate makes certain decisions. And then you review that. I mean, it's going to ultimately be your decision. So I've already had that practice where I've had to sit there and review the transcript or listen to an audio of the hearing that was in front of the magistrate and review it. There is a deep divide in that about, do you remand it or do you just correct it? I think it has to, if you're going to correct it, you do have to have the law, case law has to be quite clear, but the law also, and the facts have to be quite clear on that to make sure you make that decision. Or you do need to remand it. And why remand it? I think one of the most important things, and one of the things that I look at when I was sitting as a judge, was to make sure people are heard. One of the things that happens at the Court of Appeals is sometimes, and a lot of it is paperwork. Paperwork just comes up to the court. Whether or not you have oral arguments, that's a different discussion, but then there's a decision that's created. And do the clients, whether it's the plaintiff and the defendant, do they feel that they're getting heard by that court? Should have oral arguments then. You should participate. You should be involved in reading the transcripts and doing everything that you need to do. I also think, though, that when the case comes before the court, there is a number of the trial attorneys or the appellate attorneys will put their errors out there. If you find something else, I don't think you need to go and find, looking at the whole transcript and finding errors that no one's complaining about. You need to be very specific to what those attorneys are looking at. They're the ones, and the clients, that's the ones that are raising those issues at.
Okay, we all often hear the expression legislating from the bench. Can you explain what that means to you and why it is important that we don't legislate from the bench?
Yeah, legislating from the bench is you just basically take a law and you don't follow it and you create it to what your personal belief is. The law says the sign should be red. I don't believe in that. I think the sign should be blue. And that's how I think it's going to be, and that's how I'm going to rule. Well, no one should do that at all. Why? How are you going to rely? And this is what happens when we have all the different districts, and why cases go to the Supreme Court, whether it's the Supreme Court of Ohio or ultimately the Court of Appeals in the federal system and the Ohio or the U.S. Supreme Court, is because certain districts do believe and read something differently. I think, again, it comes back to your philosophy and whether or not you're actually reading what the statute is and what that true meaning of that is. You need to make sure you stay within that range. Don't be sitting up there changing that law. Because in Ohio we're elected to review the cases that come before us. If you want to legislate, and there's a lot of judges out there that love to legislate, I challenge them to go to the court, go to the State House. I've been there, I've done that, I've understood that. I want to take that experience and make sure I understand, make sure I don't legislate from the bench.
We have 3 branches in this country, and so when a judge legislates from the bench, that judge is taking the role of someone else. That's not what they were elected to do in this state. The example is, again, let's say you're a judge and you're traveling through a school district and you don't feel like it should be 20 miles an hour because you're late to work. It should remain 35. You're not concerned about that. So then the next case that comes up on a little speeding case, all of a sudden you say, you know what, that speed zone which was set by the council, by the state, wherever that is, that doesn't matter. I'm going to say that that person who was going 35, 40 miles an hour in that 20 zone was not speeding. That's the example. That's the example of someone taking over someone else's role, and they weren't elected to do that. That's legislating from the bench. I think a lot of us don't favor that. We just don't see that that's the role of the judicial officer.
Okay, how would you best describe your judicial philosophy?
Conservative. So we have stare decisis. So what that means is when we look at cases, when we decide cases, we have to look at precedent. We have to look at what has been decided before. And so, again, when we think of the way we look at decisions, how do we approach them? Do we legislate from the bench? Do we take a liberal point of view and say, you know what, I never really liked that zoning, I didn't like that code, I didn't like that law? I don't believe so. So when I think of my decision making, when I've done that as a magistrate, I think of, let's look at the statute, and I'm going to take a conservative and measured approach to decision making. I'm not just going to say from the bench, I think this, because my opinion in that sense doesn't matter. What's before me? What do the facts show, and what is the law here? And so from that standpoint, it's pretty easy. Conservative decision making is what I believe in.
The best way I can describe my judicial philosophy, we've talked of how we would analyze cases, but I think it's the same from when I was sitting as a judge to if elected as the Court of Appeals. One real simple thing, people come before the court to be heard. So you have to take the time to listen to them. Now in the Court of Appeals, where does that happen? Well, you've got to read the transcript. I mean, well, hey, we have law clerks, but I think it's important that the judges actually read those transcripts. When I was on the bench in juvenile court, that was one of the things that I wanted to give everybody the opportunity. Whether you can sit there and analyze their pleadings and what they've read, if you give them the opportunity to be heard, I think that's the first step. I think that's my judicial philosophy. Everyone has that right to be heard. Upon being heard, then you apply the facts that came out in the hearing to the law that applies. It's, you know, a lot of times we make it a lot more complicated than we need to, but that's just the simple process. When you're as a Court of Appeals, when you look at that, you look more at, did the judge apply the right law to those facts that were brought out in the court? And again, you're not to interpret, oh, well, those facts could be this or those facts could be that. No, what happened in that courtroom? I mean, the lawyers are going to be pretty tricky in the sense on their briefs to be highlighting certain things. I think it's important to read what they want to argue, but I also think it's very important, and that's my judicial philosophy, is to go back to that transcript, back to where those people were being heard, and apply that to what the challenge is that is being made.
Okay, thank you, gentlemen. And I know right now in your jobs you spend many hours and hours reading briefs and case law. And I think when I've talked to judges and attorneys to try to ask them, you know, what's a good question to ask a candidate for Court of Appeals? And the biggest one, or the first one right off the top of their head, is just, how do they stay awake reading all that stuff? But we'll go ahead and on with our closing, and we'll start with Jeff. 2-minute closings.
Thank you very much. Now you get practice in trying to read all those transcripts and practice in trying to make sure we understand everything. But I do ask for your consideration for your vote on March 17th. It is important. One of them, again, I'll go a little off script here in the sense to say, please get to know all your judges from the top down. We want to make sure we have the right individuals in those spots. And don't forget the judge positions. A lot of times there's missing, people don't come all the way down that voting ticket, so I encourage you to continue to come down. I ask for your consideration and vote simply because I have the experience, not only as a legislator and understanding how laws are made, I have the experience of sitting on the bench, not only as a magistrate, but as a judge. In the 24 plus years of practice, my trial experience at all levels, municipal, common pleas, and federal levels, that experience counts when you're looking at reviewing what the trial judge has done. Thank you very much.
I've had the great fortune of practicing on all sides of appellate law. And what I mean by that is, I've been on the prosecution side, which is the state side, and that's important to me. I think safety and opportunity for all of us is important. I'm from here, I have a strong commitment to our community. That's important to me. I've also had the opportunity to defend people on the defense side, and that's important as well because we have a constitution that gives them that right, the right to appeal. So I've had that good fortune to represent defendants in certain situations. And finally, I've really enjoyed teaching. I teach appellate law, I teach appellate practice and procedure. That's not one thing I talk about all that often, but one of my tax professors from 1997 came to one of my events and he said, you've got to really hammer that. You have to really talk about, the school asks you every year to come back as an adjunct professor. In fact, I just received an email 2 days ago that said, hey, instead of teaching on Thursday this year, can you teach on Tuesday? Well, of course, it's a fall class, so they're already preparing their schedule. So I really start my simulation, my practice in the summer, so I'm prepared to teach those students. But it's those experiences that are pertinent to what an appellate judge does. And my pledge to you is I'll work hard as your candidate, and I'll work hard as your judge. I'll continue to teach at the University of Dayton School of Law. I'll continue to teach second and third year law students to feel comfortable in front of the Court of Appeals, to be able to communicate their position, to be able to argue, to be able to write. Because that's important for all of us, right? We all want the right decision. We all want a well-written brief, a well-argued side. That's important to all of us. We want that safety and opportunity for us, for our parents, for our children. Thank you for your vote on March 17th.
Okay, thank you, gentlemen. And for the primary, it's an easy task. You either have to vote for one or the other of these gentlemen. You've got two choices. In the general election, it's not quite that easy because right now the judicial candidates, there's no party designation. So whichever candidate, not unless they get it changed before the general election, because they're talking about putting or it's in the legislature now. I doubt if it'll pass before the November election, but about putting party designation on judicial candidates on the ballot. This year for the general, we don't have to worry about it in the primary because we're all voting Republican, but in the general election we have to remember Sharon Kennedy and Judy French, and whichever one of these gentlemen win the election on March 17th. Thank you for coming, and now I will turn it back to Keith.
Again, I just want to reiterate, we're privileged to give this opportunity for the general public to get a look at the candidates. We're thankful for the candidates for Second District Court of Appeals and our commissioners and all the folks here that helped organize and make this thing run. Again, also want to stress that these guys aren't going away. If you've got personal questions that you want to ask and talk to them about, we certainly appreciate your demonstration of self-governance and getting to know your candidates in a better way. So with that, the meeting's concluded. Thank you.